Resuming debate, the Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
Thank you, Madam Speaker, and I'm very pleased to speak this morning with respect to Bill C-230, an act to amend the Criminal Code, intimidation of healthcare professionals, which was introduced by the member from Carlton Trail Eagle Creek, and I want to acknowledge that I'm speaking today on the traditional unceded lands of the Algonquin people. The stated goal of Bill C-230 is to protect an important right, the right to freedom of conscience and religion, which is guaranteed by Section 2 of the Canadian Charter of Rights and Freedoms. A laudable goal, but one I do not think this bill achieves. The bill proposes to create two new criminal offenses that seek to protect the right of healthcare professionals, including medical practitioners, nurse practitioners, and pharmacists, to object to taking part in the provision of medical assistance in dying, to provide services according to their conscience. First, it proposes the creation of a new intimidation offense, which would prohibit the use of coercion or any intimidating behavior to compel a healthcare professional to participate directly or indirectly in the provision of MAID. Second, it proposes the creation of an employment sanctions offense, which would prohibit employers from refusing to employ or to dismiss healthcare professionals solely because they refuse to participate directly or indirectly in the provision of MAID. Nous sommes certainement tous d'accord.
We are no doubt all in agreement that it is essential for the rights of freedom of conscience and religion be protected, not only for healthcare professionals in the context of medical assistance for dying, but for everyone in Canada.
This is central to ensuring that we're able to live our lives both personally and professionally with equal rights and dignity. However, as I will explain in my remarks today, I do not believe that the proposed criminal code amendments are necessary to protect this central right, and so I must oppose this bill. The proposed intimidation offense, which would prohibit the use of coercion or intimidation to compel a healthcare professional to participate in MAID, is largely duplicative of existing criminal code offenses. For instance, the criminal code already prohibits the use of violence, threats of violence, intimidation, or attempts at intimidation to compel any person to abstain from doing anything that they have a lawful right to do, or to do anything that they have a lawful right to abstain from doing, which is in Section 423. The criminal code also makes it an offense to extort someone, which is to use threats, accusations, menaces, or violence to induce or attempt to induce that person to do anything or to cause anything to be done, which is in Section 346. These are both indictable offenses and are punishable by a maximum of 14 years imprisonment and life imprisonment, respectively. The existing offenses of intimidation and extortion apply in all circumstances, including in the context of the provision of MAID by healthcare professionals. I believe that these offenses provide sufficient protection for healthcare professionals who do not wish to participate in the provision of MAID. The proposed employment sanctions offenses would prohibit employers from refusing to employ or to dismiss healthcare professionals simply because they refuse to participate in the provision of MAID. This is a valid and important objective, but I urge us to reflect on how such a provision may encroach on provincial and territorial jurisdiction. As all members of this House are aware, MAID falls under the shared jurisdiction of the federal government, which has a jurisdiction over criminal law, and of provincial governments, which are responsible for the provision of health care. However, with the exception of federally regulated sectors, employment-related matters generally fall within the responsibility of the provinces and territories. As such, employment concerns may be more appropriately addressed by the regulation of employers at the provincial and territorial level. Irrespective of jurisdictional issues, I also wonder whether the criminal law is a right tool to address employment issues. I'm also mindful that even though the preamble of Bill C-230 suggests that it seeks to respond to circumstances where practitioners are required to make effective referrals for MAID. The bill would not address that issue because the professional orders that establish those policies would not be captured by the proposed employment sanctions offense. We must remember that the MAID legislation simply permits the provision of MAID. It does not compel anyone to provide it, whether directly or indirectly. In fact, it contains a provision explicitly clarifying that nothing in the criminal code compels an individual to provide or assist in providing medical assistance in dying, which can be found in section 241.29. I am not aware of any evidence that suggests that healthcare professionals are being coerced or intimidated to provide MAID, and I wholeheartedly believe that the criminal law already offers protection to anyone who may be coerced to participate in MAID. I would also like to remind members that the criminal law should be used sparingly. I would also like to note that the proposed offenses only offer protection to healthcare professionals who object to taking part in the provision of MAID. They would not apply in circumstances where a healthcare professional may wish to provide MAID but is coerced or intimidated to abstain from providing it. And I have to question why we would resort to creating a new criminal offense to protect one healthcare professional's freedom of conscience, but not another's. Canadians have varied opinions on MAID depending on their personal circumstances, beliefs, and experiences. Despite these diverse views, public opinion research consistently demonstrates strong support for MAID. Our MAID laws recognize the importance of permitting access to MAID as a means of relieving intolerable suffering for competent adults. They recognize that those who wish to access MAID should be able to do so, and available statistics show how many Canadians do choose to receive MAID. Since the first legislation in 2016, up until the most recent data released by Health Canada covering 2020, there have been 21,589 medically assisted deaths in Canada. The vast majority of persons who have received MAID had cancer as their main underlying condition, followed by persons who had cardiovascular conditions, chronic respiratory conditions, and neurological conditions. This trend is consistent with the leading causes of death in Canada, which lists cancer and diseases of heart as the number 1 and 2 causes of death, respectively. It can be found in the second annual report on medical assistance in dying, 2020. Madam Speaker, MAID is a complex and deeply personal issue that engages fundamental rights and interests both for persons contemplating MAID and for the healthcare professionals who choose or choose not to participate in the provision of MAID. MAID is anything but straightforward, and we must continue to work together to find appropriate and effective solutions to balance the rights of persons to access MAID and the rights of healthcare professionals to provide quality care and service in accordance with their conscience. I appreciate the spirit of this bill, but I continue to have real concerns that it would appear to be an improper use of the criminal code and must therefore oppose it. Thank you, Madam Speaker.